Jay-Z's lawyers are going with a new tact in an attempt to get the civil lawsuit dismissed early. They basically sent a letter to the judge and said, Judge, can we have permission to file to dismiss this case? And the judge says, you have permission to file to dismiss. Doesn't mean the case is going to be dismissed, but you have permission to file. And the argument that they're making is, and I'll do a little background, these lawsuits are filed under the Gender Motivated Violence Act in New York City. This affects the 5 boroughs, not the entire state of New York, but it basically means actions have to happen in those 5 boroughs. And the quick version of it is, usually there is a statute of limitations on filing civil cases, 2 to 3 years. Well, what New York did is they said, this isn't fair. Some of these situations happened a long time ago. And if they happened a long time ago, we need to have an avenue. We need to have a vehicle in which regular people can bring lawsuits. We shouldn't stop you because sometimes it takes a while for people to want to bring their actions. We shouldn't say you don't have a right to bring an action because you did not bring it within 2 years of the time that you were accosted, the time that you were hurt, the time that you were treated differently just because of your sex. So the Gender Motivated Violence Act, or GMV, which is commonly known as, came along and they said, and it was passed in December 2000, and it said, look, you got a 2-year window. You got a 2-year window in which you can bring a lawsuit for anything that happened to you. But you got to bring it within these 2 years, and it was extended again. And so now realistically, up until I think March of this year, you can bring a lawsuit between March of this year on something that's happened to you 30 or 40 years ago, or that was my understanding. I think that was a lot of other folks' understanding. Jay-Z's lawyers are saying because the allegations against him are from September of 2000, and the Gender Motivated Violence Act wasn't created until December of 2000, you shouldn't be able to bring this lawsuit. Couple of problems with that. I don't think that's the purpose. What he's saying is the law doesn't have a retroactive element. It doesn't talk about stuff that happened in the past. Here's my position from a lawyer standpoint and from a PR standpoint. Let's say, for argument's sake, the judge agrees with him. Let's say the judge says, you are right. Jigga, jigga, nigga, jigga. Let's say he says you are right. If he says he's right in that situation, you have a worse PR mistake than you had before, because now what's going to end up coming out are people are going to say you won on a loophole, you won on a technicality. You didn't fight it and say you didn't do it. You won because you said it may have happened, but it's barred by the statute of limitations or it's time barred. I just think that's going to be a mistake. Number 2, they also said, Judge, even if you think that this case should go forward, which I think it should, but even if, Judge, you think it should go forward under this, you can't prove that this actually happened in New York City, in one of the 5 boroughs, because we think it happened outside of New York. Well, that is also going to come through discovery, that they're going to have to go and they're going to have to talk to this little girl. They're going to have to take depositions. The judge is not going to throw it out based upon that because they still have to do full discovery to determine where this action actually happened. So I don't think it's going to get thrown out. And third, the final argument I think they made is this Jane Doe could have brought this under the Child Victims Act in New York, which protects people who are minors at the time things happen. But if they would have brought that, they would have had to bring it before August 2021. And the argument is, since it wasn't brought in August 2021, they shouldn't be able to bring it at all. The fuck? Again, these are all decent legal analysis, but bringing this early, the thing that's going to start happening is, bro, you're going to start taking these L's. Taking these L's ain't good, because if you lose all these things, then publicly it's going to be your lawyer continues to take L's. Okay. 2, if you win, public perception is going to be on, you just ran through a technicality and got through this. Realistically, what's going to end up happening? Realistically, what's going to end up happening is the judge is going to say, let's get through discovery. Let's see what's happening. And all of these things may be ripe for summary judgment. Summary judgment, as we talked about, is where the court says, we've heard all the facts, have all the background, have all the information necessary, and now I can make a ruling. It's an interesting tack that his attorneys are trying, throwing everything against, but I think it could end up hurting them in the long run. Personally, I think it would have been smarter to get all of the information absolutely necessary and then make a generic, huge motion to dismiss to say that there are no factual basis to support this case whatsoever. I think going the technicality route and going the does not fit under the statute route could hurt, because at that point in time, someone could say, well, he said he did it, but they couldn't prove it. Never want to take that tack. Take that tack.